What are the steps for completing a probate in Oregon? I'm Freeman Green with Freeman Green Law, and let's take a look at what those probate steps are. So, first thing you need to understand is that probate is a state-specific procedure. I'm going to be talking about what it's like to do a probate in Oregon from a big picture standpoint. The steps I'm going to go through are the steps that I help folks take when we work through to complete a probate. Probate in other states can look very different from this. So, if you are not looking to do a probate in Oregon, you should turn this off and you should go look at something else because this will not be very helpful to you. So, probate in Oregon. This is a long list and a lot of words, and that's because there's a lot of steps that need to be taken in probate. Let's start working our way through this list. First thing that happens is after someone has died, if we are required to file a probate, then we'll prepare an initial petition. Let's pause there though, and let's just ask the question, well, how do you know if you need to do a probate? Generally, a probate is triggered when a person has passed away and they owned assets in their own name, and those assets did not have a beneficiary designation in place on them. That will usually trigger a probate. Now, there's some exceptions to that. In some cases, things like vehicles can pass free of probate. In some cases, we can do a much simplified probate proceeding called a small estate affidavit that eliminates most of these steps. But those are exceptions to the general rule. And when you talk to an attorney, the attorney will tell you if you fall under one of those exceptions for no probate or a simplified probate proceeding. But if a person dies and they own property in their name without having a beneficiary designation on that property, then we're going to be looking at probate. And the first step in a probate is to file something called an initial petition. And in the initial petition, here's what happens. The initial petition is going to tell the probate court that the person has passed away. It's going to give the court information about the person that's deceased, and it's going to ask the court to appoint someone that's called a personal representative to serve and handle the executor roles of administering and being in charge of the probate. So that initial petition gets prepared and it gets filed with the court. Very important that if there's a will, that the original signed will get filed with the probate court along with the initial petition. And you won't get the original will back. It will stay at the probate court. Then the court will receive those documents and process them. And after the court processes them, the court will issue a judgment appointing a personal representative. When that happens, the person that will serve as the personal representative can take that judgment and can show the judgment to a bond company. And in many cases, the personal representative is required to obtain a bond, which is kind of like an insurance policy. The bond company will issue the bond. The attorney will then file proof of bond with the court, and then the court completes the personal representative's appointment by issuing something called letters. And these are called letters of administration if there's no will, or letters testamentary if there is a will. These court-issued letters are the personal representative's badge of authority. This is what the personal representative shows to third parties like banks and financial institutions or title companies to prove that they're authorized to act with regard to probate assets. Once the personal representative is appointed and they have letters, they can then obtain a tax ID number, often called an EIN. And they can use that EIN to open a bank account. And the estate bank account under the EIN of the estate is where the personal representative is going to consolidate all of the assets as assets are sold or as probate accounts are closed. Then the personal representative, or the personal representative's attorney in most cases, is going to send notices to interested parties. Generally, that's going to be people that are named in the will as beneficiaries. If there is no will, then the people that would inherit are called heirs. Heirs always receive notice. And there's also a couple of government agencies that we're required to give notice to. So formal notice that meet the requirements of the law gets sent to those interested parties, and then we file proof that the notice has been sent with the court to show that that step has been done. Then we come to the publication of notice. This is usually done at the same time that notice to interested parties is sent out. We're required to publish a notice in the county in which the probate is taking place, and that is a general notice to creditors. It needs to meet specific requirements, including it needs to be published once per week for 3 consecutive weeks. Once that is complete and paid for, the newspaper will give the attorney something called an affidavit of publication, and we file that in the probate court to prove that this step has been done. These 2 steps start a 4-month creditor claim period. And during that 4 months, it's important to monitor the mail. It's important to watch for and seek out any legitimate creditor claims that might be due. And as you seek out creditors, you need to see that they are paid and that all of those legitimate creditor claims are correctly handled and dealt with. Really, really important that if you think the estate might be insolvent, in other words, that there's not enough assets to pay all of the creditors, then don't pay any of the creditors and make sure you talk to your attorney, because there's a special procedure that's done for insolvent estates. Then, as a part of this process, this inventory, the inventory filing is usually done at the same time or close to the same time as the notice to interested parties being taken care of. The inventory is a list of all of the assets and their estimated date of death values, and this gets filed with the probate court. Here, usually we're only reporting just the assets that are going through probate. If there are non-probate assets, we typically don't include those on the inventory. Then, our 8th step here, each year you're required to file an annual accounting with the court that gives the court a detailed financial update on the status of the probate. Hopefully, we have completed the probate process within a year. But if we haven't, and there are outstanding steps that need to be taken, then we file an annual accounting with the court, reporting to the court on the status. Once the 4 months has run for the creditor claim period, and creditors have been handled and taken care of and claims paid, usually at that point we can get ready to do something called a final accounting. Now, we will file a short document with the court that's called a declaration of compliance that tells the court that creditors have been taken care of and that a proper creditor search has been made. And then when we file the final accounting, we report to the court in detail on all of the financial transactions of the estate. We'll tell the court that all of the steps have been taken and that we're now ready to distribute. Now, in some cases, instead of doing a final accounting, we can do a simplified accounting or a simplified statement to the court. This is sometimes called a verified statement or a verified statement in lieu of final accounting. And when we can do a verified statement, it simplifies the final accounting. It makes it much less expensive to complete the probate. The verified statement can only be done if all of the interested parties, all of the people that will be inheriting, sign off and consent to this simplified statement. Once that is filed with the court, in some cases, we need to give additional notices to beneficiaries, and there's an objection period. And the court will then process those documents and issue a judgment that allows for distribution. And at that point, then the personal representative can distribute the assets to the people rightfully entitled to inherit them, as approved by the court. Usually at that time, there are some attorney fees that get paid from the estate. Sometimes there are final accounting fees that get paid. So the distribution gets made. As the personal representative makes the distribution, they collect receipts proving that the distribution has been completed. Those receipts get filed with the court, and once the distributions are complete and all of the receipts are filed with the court by the attorney, proving that the distributions have been made, there will be a final judgment that gets filed with the court, and the judge will sign the judgment, and that will close the estate, discharge the personal representative, and the probate is then complete. There's often, after the probate is complete, a final step, which is the filing of an income tax return, letting the government know that the estate is complete and that all income has been reported as required. So those are the big picture, quick summary steps for completing a probate. This is typically in Oregon what your attorney will work through with you in completing. Probates can vary quite a bit from case to case. In some cases, some of these steps can be eliminated. In some cases, there are extra steps in addition to these. Sometimes folks will ask me, Freeman, do I need an attorney to complete the probate process, or can I just do this myself? That's a tough question, because when folks do it themselves, I only see it when it goes wrong. But in my experience, folks need to have an attorney help them through this process. The steps that it takes to complete a probate and the forms that are required, the best thing that I could compare it to is it would be like filing multiple income tax returns, but you're not given a form to do it. You have to create your own form and then file the correct document. In general, the best thing to do is to hire an attorney with experience in probate and have them help you work through these steps. Thank you for watching. I hope that was helpful to you. If you think that video might be helpful to someone else, please feel free to share it with them. And if you think that our law office might be able to help you with trusts, probate, or estate planning, please feel free to contact us. Thank you.